Welcome back to Taxpayer Empowerment. I'm Jose Melendez with the Texas Public Policy Foundation. Today we're diving into a case that could have major implications for government transparency in Texas, not just for school districts, but for cities, counties, and government agencies across the state. The case starts with allegations surrounding at least $1.1 million missing from an upscale tennis center funded by taxpayers in Highland Park ISD. There were whistleblower allegations, accusations of kickbacks, and concerns involving district leadership. The district conducted an investigation, but when the public asked to see the report, the district refused. That refusal eventually led TPPF all the way to the Texas Supreme Court. Joining me today is my colleague Nathan Seltzer, who has been deeply involved in this fight for transparency. So Nathan, thanks for joining us today.
It's great to be here, man. Thanks for having me. This is an important case for transparency and for every taxpayer in Texas, so it's great to talk about this.
Absolutely, and I think a great starting point would be just the basics. For someone hearing this case for the first time, can you just give us the top lines? What exactly happened here in Highland Park ISD?
Well, I think it's better to start at the beginning.
Okay.
So the Highland Park ISD in North Dallas encompasses cities of University Park and Highland Park. They have a taxpayer-funded tennis center. And it's an upscale, it's a very nice facility. It was renovated in 2017, and they employ a lot of tennis professionals there, about 24 of them. And they give lessons, like obviously they're working developmentally with the students who are tennis players in Highland Park ISD, but anyone, including people even out of district, can pay for memberships of Highland Park ISD, of the Seay Tennis Center. And then they can use those memberships to get lessons from the tennis pros. And so that's been going on. The Seay Tennis Center was actually built in the 1980s, although it was renovated in 2017. So that's been going on for a long time. What happened at the center, though, was that up until pretty recently, the lessons that were paid for by residents or in the area, that were paid to the tennis pros, were only allowed to be in cash or check. So there was no electronic transactions and no electronic record or kind of electronically auditable record of the transactions book that could be used to track payments and like how much income was coming in and who was collecting the income and that sort of thing because of these sort of cash transactions. And as early as 2015, we have the concerns. We have like a letter that we put all this information in our case that we brought under the Texas Public Information Act. But there's a letter from taxpayers from 2015 detailing concerning allegations about these cash transactions at the Seay Tennis Center. And it details, like they're mentioning that many of the, first of all, that the whole thing's conducted in cash or check, there's no electronic record or anything like that, and that many of the transactions, there's no record of them potentially, and that there's allegations that some of the tennis pros were being asked to invest in sort of the side hustles or these business ventures of upper-level administrators in the Seay Tennis Center. So this letter going back to 2015 is pretty concerning in terms of its allegations. Allegations obviously aren't proof, but it would be something that if you're running the Seay Tennis Center, you should be concerned about.
So let's do a deep dive on that. So in addition to the allegations of $1 million in taxpayer dollars tied to this facility, there's allegations of kickbacks, misconduct by employees and administrators. Can you talk to that?
Yeah, so there's no investigation based on this letter, at least that we know of, from 2015, but there's taxpayer sentiment is building and pressure is building on HPISD to investigate and make some changes to the Seay Tennis Center. Nothing happens for a number of years until 2020. A whistleblower comes forward named Jason Holland, who was a tennis pro working for the Seay Tennis Center. And he says that he was fired because he would not participate in this kickback scheme that was that Highland Park or that the Seay Tennis Center administrators, he says they were engaged in. So they were asking him for money, for investments, and he wouldn't participate, and so he was fired. At that point, Highland Park, again, this whistleblower thing is made public, and that more taxpayer pressure builds on Highland Park, and so they make a change at the Seay Tennis Center to require that all those lessons with the tennis pros, instead of being paid in cash, that now they're going to get paid electronically with records. So credit card and other electronic transaction formats, no more cash, no more checks. Once they do that, we have financial reporting from HPISD shows that the revenue at the Seay Tennis Center increased by $1.1 million. So if we just look backwards, where was that $1.1 million? Because this is in 2021 that we had this revenue increase. Where was that $1.1 million in 2020? Mm-hmm. What about 2019, 2018, 2017? How long does this go back? Because remember, these allegations surfaced in 2015, and presumably that was not the beginning of this thing. So we don't actually know potentially how much money is missing from the Seay Tennis Center, but certainly that year-over-year revenue increase of $1.1 million is a huge red flag. So this should, if you're a taxpayer of Highland Park Independent School District, that revenue that should be coming into the Seay Tennis Center, that should be offsetting, that should be paying for their staff, that should be paying for the facilities. And then the money that's being used to run that tennis center should be used for curriculum to improve student outcomes and those things. But that money's the lost money creates a problem, and it's hurting the whole school district, not just the Seay Tennis Center.
Nathan, you hit the nail on the head. So when we talk about taxpayers, usually when we hear the word investigation, we expect that we're going to get answers. That didn't happen here. Why didn't that happen?
Well, believe it or not, at this point, there still had not been an investigation. So we have potentially millions of dollars missing. They had changed some of the underlying financial management of the facilities to have those electronic payments, so there's better accountability. But they had, at this point, still not conducted an investigation. Once that revenue increase of $1.1 million, that was really became a focal point. Again, we have this taxpayer sentiment, like what's going on. And so at that point, they finally conducted an investigation, and they used a third-party accounting firm to do sort of a forensic audit, and that firm is Whitley Penn, and they used that firm to investigate the internal finances of the Seay Tennis Center and determine exactly what was going on.
So the Texas Public Information Act comes into play here. One of the most striking lines in Texas law says, and allow me to read it, "The people in delegating authority do not give their public servants the right to decide what is good for the people to know and what is not good for them to know." That's an incredible, strong statement.
Right.
When you think about transparency. So how did we go from that principle to a school district claiming taxpayers cannot see the investigative report?
Yeah, so they didn't release the investigation, right? They conclude they conclude the investigation. It's done. And then, like, some taxpayers send inquiries. Hey, we heard that there was this independent investigation that was going on. It's concluded now. What happened to the investigation? Where is that? What can we see it? What happened to the money? And in responding to those allegations, Mike White, who is like an assistant superintendent who was in charge of Seay Tennis Center, said, well, we conducted an investigation with Whitley Penn, and there's no malfeasance, there's no financial mismanagement going on, kind of nothing to see here, let's just move on. But he didn't release the investigation still. Well, this is where the Texas Public Information Act comes in, because the Texas legislature says that when there is a report or an audit or anything like that conducted by a government body, which Highland Park Independent School District is a government body, whenever it's investigating for a government body, in other words, the government body is commissioned the investigation, or it's investigation of a government body, meaning it's the subject of the investigation, then that investigation must be made public under the Texas Public Information Act. And all that should be required is that you or me or any taxpayer send a public information request saying, hey, we'd like to see that report. We know it's called the Whitley Penn report. We'd like to see it. And that should have been released, and that should have been the end of the story. It wasn't.
So on that, I know that the district argued attorney-client privilege.
Yep.
For our audience, take a moment to just explain in plain English what that means.
So everyone's probably familiar with attorney-client privilege a little bit from Law and Order or Matlock or whatever's going on. But attorney-client privilege is a special, long recognized privilege going back to before the founding of our country that says that when you're having a conversation with your attorney, that communication is confidential and it's not available for discovery in court, or it's not available to like a prosecutor in a criminal case against you. That's a good thing, because what it does is it allows you, if you're being investigated, that you can be honest with your attorney, tell him anything that's going on, and you don't have to worry about the prosecution getting that and twisting like a fact that maybe it sounds bad, but it's not, or whatever the reason, that the attorney can do the best possible job representing you, because if you're being criminally indicted or criminally investigated, because the communications with him are kept secret. But you might be thinking, but the third-party accounting firm here isn't an attorney, and it was commissioned by the school district. So how would attorney-client privilege even be relevant here? And ordinarily it wouldn't. It's not. It's common sense that attorney-client privilege would not even be relevant to this case. But when Highland Park commissioned Whitley Penn to do this a financial audit in its capacity as an accounting firm, it's a financial audit of HPISD, they just sent it through an attorney. So they had an attorney also involved, and so it was like a three-way contract. So they said the attorney and Whitley Penn and the school district are having an agreement to conduct this investigation. And the school district said, that's enough. That puts the entire investigation under attorney-client privilege. We think that's wrong. That's not how attorney-client privilege traditionally works. Mm-hmm. But it's especially wrong here because we have the Texas Public Information Act, and it says that if it's an audit, a report, an investigation, that those things are public information and they're available to the public. So we have kind of this pressure point where attorney-client privilege is sort of being used as a weapon against transparency, and that's not the way attorney-client privilege was supposed to work at all, and it's not the way it normally works. And I'll give you an example of that. So like if you, I know you would never, I'll use myself as an example.
Sure.
Let's say I committed fraud and I had the files that proved the fraud in my file cabinet at home. Mm-hmm. If I told my attorney about those files, say, hey, I got all the fraud files in my file cabinet at home, don't let law enforcement know about it or whatever, the government can't go, like the prosecutor can't go to my attorney and say, hey, you got to tell me about where he keeps his files, because he only knows that because I communicated it to him. But that doesn't mean that the law enforcement can't get a warrant and search my file cabinet at home and get that information. I can't then say, oh, but I told my attorney about it, so now that whole thing is protected by attorney-client privilege. That doesn't make any sense. Those files exist. That's factual information that the government can certainly use, as long as it acquires it legally, that the government can certainly use to prosecute me. And in this case, it's really more like, this case is really more like the example of I told my attorney about it, and so the facts are not relevant. Does that make sense?
Yeah. So on that, I think that it's very helpful for our audience moving forward in our conversation. But you also brought to my attention a case dealing with the Supreme Court back in 2001 with the city of Georgetown. You want to talk about that?
Yeah. So when we raise this, I'm like, we said in our briefing, well, this is not, like early on in the case, this is not how attorney-client privilege works. Mm-hmm. They raised this case. It's in Ray, city of Georgetown. It's from 2001, Texas Supreme Court case. And it said that actually I got the language from the TPIA here. It says that core public information must be released unless made confidential under this chapter or other law. And so the In Re City of Georgetown case says that other law includes, like through sort of incorporation of the Texas Rules of Evidence, it's kind of legalese, but basically that it includes attorney-client privilege. Even though the Public Information Act didn't say attorney-client privilege, and attorney-client privilege does not mean confidential, it says confidential. And attorney-client privilege stuff is not confidential. And there's a distinction between privilege and confidential, which is not really super relevant to this discussion. It kind of gets into the minutia of the case. But they basically said that other law means attorney-client privilege, even though the legislature did not say attorney-client privilege. And there's a lot of reasons why the legislature clearly wasn't thinking about attorney-client privilege when it made this ruling. So we think this is just a bad ruling by the Texas Supreme Court from 2001. We're 26 years ago, that they just misconstrued the statute, and that case should be overturned. I think it's interesting that one of the members of the Supreme Court, none of the members of the Supreme Court at that time are still on the court, but one of the members that wrote a dissent of the In Re City of Georgetown case from 2001, and that was Justice Greg Abbott. And he said that is not what the Texas Public Information Act does. It does not incorporate attorney-client privilege. And in fact, if you incorporate attorney-client privilege, what you could have is that government entities, and school districts are government entities, could use attorney-client privilege to conceal all kinds of information that the Public Information Act makes public. That can't be what the legislature intended, because it undermines the very purposes of the Texas Public Information Act. The Texas Public Information Act, one of the quotes from the act says, "The people insist on remaining informed so that they may retain control over the instruments they have created. The provisions of this chapter shall be liberally construed to implement this policy." But really what the court did here is they liberally construed it to not implement the policy of transparency. They implemented a policy, they liberally construed it to keep secrecy in the statute. And that's become a problem over the years for the TPIA.
So essentially the problem at hand here is that governmental entities are taking these damaging information, they're handing it to their lawyers and then shielding that information from the public forever. Is that
forever, right? By the way, normally if some information is accepted from disclosure through other means like copyright and things like this, that information can at least be released after 75 years. But if it's confidential, then it can never be released. So even after 75 years, the public would have no more right to the Whitley Penn report than they have right now. So Greg Abbott in his dissent, at the time, Justice Greg Abbott in his dissent in this case, he was joined by 2 other justices. It wasn't enough, but he was exactly right. And what he predicted would happen is what we're seeing happening here.
So one thing that stood out for me was the amicus brief that was filed against TPPF. Mm-hmm. It encompasses a broad coalition. So it isn't just Highland Park ISD anymore defending itself. It's these organizations such as the Texas Association of School Boards, right, Texas Association of Counties, and other organizations of that nature. These are all taxpayer-funded entities, right? Their membership dues are funded by our tax dollars. You know, these entities, they represent cities, school districts, counties. Why are they so nervous about this case?
Well, they should be nervous. And because what this does is it reveals two reasons, but I think the big reason is that this reveals the conflict that these organizations have with their constituents, with their taxpayers. Because the taxpayers demanded transparency, and that's what led to the Texas Public Information Act. They're now lobbying, saying we don't want transparency. And it's the exact opposite of what taxpayers want and, in fact, demand. So the language that you mentioned from the Texas Public Information Act, and I mentioned that the school district is an instrument of the people, of the taxpayers. It does their will. So it should release the information when the people demand it. And they shouldn't be able to rely on sort of this old sort of misguided decision by the Texas Supreme Court and a twisting of the common law and what attorney-client privilege is to be able to keep all kinds of information secret. By the way, we're not, just for the record, and for anyone listening, we're not seeking the attorney-client privilege, like the legal advice that Highland Park's attorney gave to Highland Park. We haven't requested anything like that. We're not interested in that. We're interested in the underlying facts. And well, I'll just leave that part there. That we're not trying to get their legal advice. We just want to see the information that they commissioned.
Sure. So let's say for a moment that the court rules in TPPF's favor. This wouldn't just affect the one tennis center here in Highland Park ISD. I mean, this would affect. We're talking about reports, audits, investigations across governments in the entire state of Texas. Would that be right?
Yeah. And the amicus brief is sort of this. The sky is falling. It's going to be the end of the world. If this old case is overturned, then public bodies will never be able, the governmental entities will never be able to talk to their attorney again. But that's not really true because the Texas Public Information Act doesn't make attorney-client communications public. It only makes reports, audits, investigations public. So if they conduct an investigation, they can't hide it behind attorney-client privilege. But that also doesn't say anything about any legal advice they get. They can, of course, still receive legal advice, and that's not public. Maybe it should be, but that's for the legislature to decide. So the legislature gets to strike that balance, not the court. So the court didn't, the legislature struck a balance here, and they said transparency applies for reports, audits, investigations. The legislature didn't say anything about making public legal advice, and so the reports and audits, investigations should be public, and we're just asking that the Supreme Court give effect to what the legislature decided.
One of the most fascinating things I think about the amicus brief is that it almost treats attorney-client privilege as this sacred right of government, as opposed to, I mean, more important than transparency.
Right.
But aren't taxpayers clients in a sense here in this case?
So we actually make that argument in our brief that the ultimate client of every government attorney is the taxpayer and is the constituent of that organization, because those public bodies, the government entity, is an instrument of the people, as the Texas Public Information Act says, that the government exists to do the will of the people. It's not the other way around. That's why they say that it's not for government to decide what the people should know and what the people should not know. And there's examples, recent examples of independent school districts in the state of Texas concealing investigations behind attorney-client privilege, just like what's happening here. So one of Highland Park's arguments and one of TASB's arguments in their brief is that this isn't happening. School districts would never conceal an investigation behind attorney-client privilege. Now, notwithstanding the fact that this is happening, they're already doing it in the very case that we're litigating right now. But there's other cases that have been in the news lately. There's a case from last year, El Paso ISD hired a lawyer to investigate hazing allegations, and the attorney report was kept secret from the public, citing attorney-client privilege. In 2024, United ISD in Laredo hired a lawyer to investigate sexual harassment and retaliation by a superintendent of the school district. That superintendent was fired, by the way, and the investigation was never released, citing attorney-client privilege. In 2025, this is still ongoing. Keller ISD School Board is attempting to keep secret even the bills that they're paying an attorney to defend them against allegations that they violated the Texas Open Meetings Act and that they violated school board policy, that they don't even want to reveal how much they're paying their lawyers to defend them in these lawsuits, and they're citing attorney-client privilege. So this is a big problem, and it's only going to get bigger, and TASB is aware of it, and because they're aware of it, they have many client school districts across the city of Texas. They give trainings on how to respond to Texas Public Information Act requests. Certainly, this if In re City of Georgetown is upheld by the Texas Supreme Court, then that's going to make it into training, if it hasn't already, because it seems to be that school districts are already employing this tactic. But we're going to see it continue to grow, this trend of using attorneys as a filter to keep public information away from the public. That's just not acceptable.
That's right. So let's dig further into this TASB and TAG brief, because I think it reveals a lot about how the establishment, how these organizations view transparency. One of their core arguments is that government officials need this confidentiality with their attorneys, when they're getting legal advice and that sort of thing. But isn't that a dangerous thing when we're talking about investigations that deal with corruption and the misuse of our tax dollars?
Yeah, it's especially dangerous when the legislature said, no, you can't do that. So courts can't override the legislature. The legislature's got to follow the Constitution. So of course, if the legislature were to violate the Constitution or something like that, then the court would have to say, no, legislature, you can't do that. But we're not even close to that territory here. No one's alleging that. What the legislature did is say, some of this information should be public, and we're going to tell you exactly what that is. And so the court can't go back and second guess the legislature and say, no, even though you said this information should be public, we really think the attorney-client privilege should apply here. That's not for the court to decide. The legislature said that this information is public, and so the court should just merely implement the will of the legislature. And just to the point, like they're raising that we won't be able to rely on attorney-client privilege, or that we have this sacred attorney-client privilege. They still have attorney-client privilege. It's just that the legislature said it doesn't apply to investigations like the Whitley-Penn report, and for good reason here, right? We have allegations of millions of dollars missing. Now, maybe the Whitley-Penn report says that everything's good, which is what Mike White said to a constituent in an email, saying there's no malfeasance, no financial mismanagement occurring. Maybe it says that. And if so, the taxpayers would feel better if they saw that report from a third-party accounting firm saying that there's no malfeasance or mismanagement. But what if it doesn't? And they have a right to know that too.
So it appears like there's an imbalance here in this amicus brief by TASB and TAC. So it repeatedly warns about how this is going to impact, how it's going to affect governmental entities. But there's almost little to no discussion in this brief about how, it's the public's right to know how their taxpayer dollars are being used. So did you notice that imbalance in this report?
Yeah, and this actually brings up a great point. So one of the arguments that Highland Park ISD raises is, well, because we asked them, we said, if this information is kept secret from us, how are taxpayers ever supposed to get to the bottom of this issue, right? Because you raise the imbalance. This is an imbalance. There's no way to get to the bottom of this. And they said, yes, there is. The public can just redo the entire investigation themselves. They can interview the same staff that Whitley Penn interviewed. They can review the same financial books that Whitley Penn reviewed, and they can perform their own audit of the Seay Tennis Center and come to their own conclusions, get the underlying facts that way. Okay, let's just pretend that Highland Park ISD would actually allow the public that sort of transparency. That the Texas legislature passed the Texas Public Information Act, and it says when the district performs that review, the public gets it. So the taxpayers already did the investigation. That's what the Whitley Penn report represents, the taxpayers getting that investigation. It's not a secret report that only governmental bodies, the masterminds behind this, get to keep. It's for the public to see. So exactly, like the balance is completely skewed.
The most interesting thing about this report is the fact that you have organizations like TASB, TAC, right? It's a whole breadth of different organizations that have signed up for this. I interact with these organizations quite a bit. We're usually on opposite sides. I'd say 99% of the time on the policy fights up at the Capitol. But in a case like this, is this common to see so many organizations sign up for an amicus brief of this nature?
I don't know the answer to that. They came in and filed this brief. And I think what it reveals is, like, I don't need to analyze their motivations and determine if they're thinking the wrong thing, because what they're doing is they're advocating for a position of judicial secrecy instead of legislatively mandated transparency. So if you're taking that stance, that's a problem. I don't know what their motivation is for doing that necessarily, but that's a problem when you're asking the court to do something that you can't get done at the legislature.
So stepping back for a bit, because this case feels bigger than just one legal doctrine, right? So it feels like a battle between government transparency laws and what it means for the ordinary Texan. Do you see it that way?
So the ordinary Texan is served by government transparency laws. That's the legislature has amended the TPIA numerous times, strengthened protections. It makes certain things confidential. For example, your taxpayer information. The government can't give out your social security number and things like this. Even if someone asks for it, even if public information, that's made confidential by the Texas Public Information Act and other laws. So it keeps some things secret, as it should, and the legislature's got to walk through and figure those things out. So that serves the public interest. But when the judiciary steps into the legislature's role and saying this is not a good idea, which is what happened in Ray City of Georgetown, and this is what Justice Greg Abbott at the time, I'm intentionally calling him Justice Greg Abbott because at the time he was the justice. What he points out in his dissent is it's just not the role of the judiciary to put a judicially crafted rule and insert that into a legislative statute that actually contradicts both the purpose and the text of the legislative statute. That's the argument that we made here. We have a much different composition of the Supreme Court now, but more originalists on the Supreme Court, and we're very hopeful that we can go back to the text of the statute and just read it and say, judiciary, Texas Supreme Court, here's what the Texas Public Information Act says, and you should just give effect to the words of the act, the plain text of the statute, and that is going to protect the interest of the taxpayers and across the state of Texas, not just for school districts, not just for Highland Park, but the other school districts I mentioned. But if it applies to school districts, then it applies to cities, counties. That's why the TAC got involved. And so it's going to lift the veil a little bit and allow more transparency for taxpayers into anywhere you're paying taxes. So that's a good thing. We think transparency and more information is always going to be better than secrecy.
So as we're wrapping up here, I'll give you two questions. So what would concern you the most if this president stays in place? But also on the flip side, let's say the court rules in favor of TPPF, what changes?
So if the president stays in place, I think we're just going to see the current trend continue. It's going to be great if you're an attorney representing governmental bodies, because you're going to get a lot more billable hours because they're going to be hiring attorneys like crazy to filter all these investigations and reports through. As I detailed earlier, that's already happening, but I think that's just going to accelerate. That's just going to continue. But for everyone else who doesn't want their taxpayers to go to unnecessary attorneys and who wants to get transparency, that's going to undermine the purposes of the Texas Public Information Act, and it's going to be a problem for transparency going forward for I don't know how long. We're not going to get another chance to take a run at this bad precedent for a long time.
So Nathan, this has been a great conversation. I think it's very illuminating for the audience. So with them in mind, think about taxpayers. Taxpayer dollars are involved in this case.
Yeah.
Do you think so as a final question, really at the central and at the heart of this issue is, does the public have a right to know?
Yes. And even if the legislature said so that should be, the legislature gave the public a specific authorization here to request this information. The public absolutely has a right to know. And the only way we can get around that is with, if the only way we can get around that is with judicially crafted rules, then the judiciary should stay far away from that. The public has a right to information under the Texas Public Information Act, and even attorney-client privilege or any other privilege can't override what the Texas legislature expressly said the public has a right to this information under the TPIA.
Nathan, thank you for engaging in this fight, and thank you for joining us today.
My pleasure. Thanks for having me.
And thank you all for listening to Taxpayer Empowerment. We'll see you next time.